Hello everyone, welcome to our podcast. Today we will discussing a commercial law case titled The Case of the Falling Fabric. This case involved three companies. First, Elegant Uniforms Indian Berhad, a uniform manufacturer. Second is a Fabric Pro Textiles Indian Berhad, a fabric supplier. Third is Aura Grand Resort, the final client. Elegant Uniform received a large order to supply 5,000 premium uniforms. The uniform had to meet a strict requirements such as being a durable, breathable, wrinkle resistant and suitable for high temperature washing. However, problems arose when the fabric supply did not meet this expectation. So today we will analyze the legal issue, relevant law under the Sales of Goods Act 1957, case law and application and advice.
Thank you. There are four main legal issues in this case. First, whether the fabric supplied by Fabric Pro was of measurable quality. This means the good must be of acceptable and standard usable. Second, whether the fabric was fit for instant purpose, elegancy clearly needed fabric, suitable for frequent industrial washing. So this is very important. Third, whether the fabric matched the description given during the contract. The fabric was described as durable and high quality. Fourth, whether the Fabric Pro has breached the contract by supplying defective material. These issues help us determine whether the elegancy uniform has the right to take legal action. Now let's move on to the relevant.
The main law applicable in this case is Sales of Goods Act 1957. There are three important sections. Section 16(1)(a), good must be fit for purpose. If the buyer informs the seller of the intended use are realized on their expertise, the good must be suitable. Section 16(1)(b), good must be of the stability quality. This means the fabric should be durable and usable under the normal condition. Section 15, good must be correspond with the specification given. If the fabric was described as high quality and durable, it must be those standards. This section clearly protects buyers like elegant uniforms.
Now let's support the law with the relevant case. The first case is Grant vs. Australian Knitting Mills 1936. In this case, the buyer suffered a skin reaction due to a defective clothing. The court held that the goods were not fit for a purpose. The second case is a Parasite vs. Last 1903. A hot water bottle burst and injured the buyer. The court ruled that the product was not for quality. Both cases show the seller are responsible when the goods are defective or unfulfilled.
Let's apply the law to our case. Elegancy uniform clearly told Fabric Pro that fabric must handle the high temperature washing, be durable for daily use, remain comfortable and long lasting. This means elegancy relied on Fabric Pro's skill and judgment. If the fabric failed, then it is not fit for purpose under section 1A. It is not of measurable quality under section 1B. It does not match the description under section 15. Therefore, Fabric Pro has breached the contract, especially a breach of condition.
Let's look at the advice and remedies for elegant uniforms. First, elegance can reject the fabric and request for full refund. Second, they can claim damages for any losses including production delays, financial loss, damage to reputation with Aurora Grand Resort. Third, they may terminate the contract because this is a breach of condition. For best practice in the future, always include clear written specification, conduct quality testing before use, include penalty clause in contracts. These steps can help prevent similar issues.
In conclusion, Fabric Pro Textile has likely breached the contract by supplying a fabric that failed to meet the requirement standards. Under the Sales of Goods Act 1957, Elegance Uniform has strong legal right to take action. This case highlights the importance of clear communications, quality assurance, legal protection in business agreements.
Thank you.